Well, good morning, everybody. It's nice to see the three people that are here, and I'm sure there's some of you online. My name is Kathy Reimann. I've been a paralegal for many years, not in civil litigation for all the years. I started out in real estate and many years ago. Then in 2008, the real estate market busted and I had to recreate myself. And I ended up in employment law in civil litigation in 2011. And I've been in civil litigation ever since then. Civil litigation is a harder, depending upon which kind of law you're in, area of law to get into. It's very directed. There's deadlines, there's processes, there's a lot more than let's say administrative law where you're in probate or you're in real estate. But in civil litigation, you start from the time somebody files a complaint until it goes to trial. And there are so many procedures that happen in between in civil litigation. As a paralegal, I think this is really important to you. Can we go to the second screen? Important to you to learn that what is going to be expected of you and how you're going to help your attorneys. The biggest thing is with these case management orders, when they came out in 2021, it really did help our lives, but it also complicated our lives. And as we talk, I'll tell you how that happened. Before these came out, we would file a complaint. We would be in the pleading phase where we file a complaint, they answer, or they file a motion to dismiss, then we responded. And then once you get out of the pleading phase, then you get into the discovery phase. And once you're in the discovery phase, you're there a long time before we would then maybe file a notice at interest, or a notice for trial, letting the judge know that our case is ready to go on this trial docket. And we have 20 judicial circuits here, and every single one of them had a different procedure. So in 2021, the Supreme Court said, we want to make a more efficient way for us to manage cases. We want to see them come to trial quicker in an efficient way. So that was this Administrative Rule Amendment 12. And the chief judge put these rules out to all of the chief judges of the 20 circuits and said, this is what we want you to do. I was so excited when I heard about this. So excited, because if you've practiced in federal court, this is something the federal court has done for years, at least as long as I practice. I don't know when they started doing it, but if you go to the Middle District of Florida and you go to one of the judges' sites, or you get into a federal case, you have 40 days to fill out a case management report, have the attorneys meet, discuss everything that's outlined in that case management report, and then you file it. And that dictates everything for your case from there on out. And guess what? Every court uses the same report, the same deadline, the same report. It's a beautiful world when you practice in federal court. Well, then the Supreme Court, I think, wanted that to be what was going to happen in the circuit courts, the 20 circuit courts. And it may still eventually happen, I'm not sure. But right now, what we're working under is 20 different sets of rules. So that's pretty much what I did. If we could go one more. So when they set out these case management rules, they said, we have 3 classes we want you to put your cases in. You're either going to go into a streamlined case. Streamlined cases are cases that typically don't have a jury trial. They have very few issues to be tried, very few documents, very few witnesses, something that a judge can hear for 2 days and make a decision. So those are the narrow and yet broad guidelines that each court uses to determine whether it's going to be a streamlined case. Then you have the general case, and I think that's where most of us fall, is under this general case management. That is a case that is going to have discovery. It's going to have some more documents. It may have a couple more issues It's going to be heard before a jury trial in most cases, which now is going to be a 5-day trial. It's going to be longer than 2 days. It's going to be 5 days. So that, and recently, I don't know if I put it out here, $50,000 was the line between county court, which is a lot of your streamlined cases, your non-jury trials. That used to be 30,000. So that was a big jump to 50,000. That just happened this year. So a lot of our cases that used to be in civil court for 35,000 now are considered county court cases. So that is huge. So you had the streamlined cases, you have the general cases, and these are all under this case management supreme order. And then they gave you the classification of complex cases. And they said in complex cases, it's not going to fall under this case management order. We want you to go to rule 1.201. That's going to tell us the way to handle a complex case. So, and that's why I put this rule here, because I'm going to tell you a story about what I did and a big mistake I made. When I started at this present law firm, I downloaded the Florida Rules of Civil Procedure. I said, okay, I want something handy that I can quick look at. So let me download it. Let me put it in my favorite place. Let me look at it. Well, we had a motion for summary judgment that was going to be heard. I'm thinking it was in 2020. I didn't put the rule out when it changed, but it changed from, I think, 7 days before the motion for summary judgment. The other side had to file their response to the motion for summary judgment. That's a big deal. You have to get that response in before 7 days before it goes to hearing. And that's what I put on our docketing. Guess what? It changed to 20 days. We were out of compliance with the rules because I was using a rule that I downloaded that was good at a certain point, not one. So if I could tell you one thing that you should do is to bookmark, and if you could open that up, the Florida Rules of Civil Procedure. This site is fantastic. The Florida Bar keeps all of the rules up to date. And as you will see there, you've got your rules of civil procedure, your rules of general practice and judicial administration. That one is a very important rule when you're in civil litigation. It points out the general practice rules, more from the civil litigation rules, but I use both of those extensively. I don't use criminal procedures, but if you go into criminal law, I mean, everything's there, your probate, your trial, your traffic court. So this is really a fantastic site for you to, when you make your favorites, when you're working, make sure you use this so that when you go to look up a rule, you find the correct rule and you're not sending your attorney down to the point where they're going to get sanctioned for not, or we're going to lose our, motion for summary judgment hearing because we can't have our response heard. So make sure you have local current rules. The other little story with that, I don't know, I think when we get to times, I think I'll bring out that story too. So on the next page, not only did they say this Supreme Court say that we want you to classify it, but here's what we want you to put in your administrative orders for civil litigation. They want them to give when is the response to a complaint due? When do motions need to be resolved? When do you object? What's the dates for that? When will mediation occur? When will discovery be cut off? So these administrative orders were set out not only to tell you what class you worked under, but how to calculate all your deadlines leading up to trial. And then at some point in that, remember how I said that we used to have no guidelines, and then at some point we would decide our case is ready for trial? Well, these orders should tell you how to go about getting your case set for trial, because this is a case management order that's going to come out. Then there's going to be a trial order. and they're going to differ. Some of them are going to differ, and that's what we'll talk about. And some of them are going to refer you back to your case management order. They're going to give you a couple of deadlines and say, but all others use your case management order. There's one judicial circuit I know that does that. I don't know how many does it, but most of them come out with a new trial order, and your case management orders are now obsolete, and now you're going to use your trial orders. In the next slide, I think. Okay, so here's your 20 judicial circuits. And this is really a nice way. If you all get this, you guys are available to click on any one of these. It'll take you right to that page. So this is in the Florida courts, and I gave you the link over here so that you could go there anytime you want to know about how the Florida courts work, or you could click on the link of the judicial circuit you're interested in. But we are in the 7th Judicial Circuit for Flagler, Putnam, St. John, and Volusia County. And so today, really, that's where we're going to focus, is in the 7th Judicial Circuit for Volusia County, because if you do work in civil litigation, that is what you're going to need to know the best. And honestly, we're really lucky that we're here, because our case management order is by far the easiest. To not necessarily for the deadlines, but let's go to the next page if we can. When a complaint is filed, that is when you've got to go to whichever circuit you saw there and find out what you're supposed to do, because it's the plaintiff's position in most cases to make sure that this case management order is either filed with the complaint, or 30 days after the complaint is filed, they've met and conferred, and now we've got a good case management plan to go. Or maybe we're going to file a notice of final service on the other side, so the court will notify of theirs. But here in Volusia County, the courts we file this with our complaint, and it's there right from the beginning. So there's no ifs, ands, or buts where our case management order is or how it's going to get there. But when I say you've got to read, I'm serious about that. When you file a complaint, you must go to your judicial circuit, read the standing order, the case management order. One's going to tell you how to do it. The other one is usually the case management order that you're going to work with to get filed and the court to follow. And it just depends upon which circuit you're in. That's how you're going to do it. Yeah, so in some cases, you're going to do what we do in Flagler. I keep saying Flagler, we're Flagler and Volusia County, or you're going to do something totally different in another judicial circuit. Okay, and so for example, in the 1st Judicial Circuit, so in your 1st Judicial Circuit, we don't have that up anymore, so we can't look to tell you which counties they're in. That's Escambia, I knew that, Okaloosa, Santa Rosa, and Walton County. It's amazing. You go to their standing order and you read it, and it's really long. It's maybe 3 or 4 pages long, and then underneath it is attached an Exhibit A, and it's a case management plan. What do you just see that? What do you think you're supposed to do? You think you're supposed to maybe take that case management plan, fill it out, and file it in the court, right? Well, no, you got to read, because paragraph 7, simple, get all the way to paragraph 7 before you ever get there. And it says, plaintiff shall file a notice of final service when the last defendant has been served. And so this is going to let the court know that they can file the case management report. If you have any changes to the case management report that the judge or the circuit files in your case, you use Exhibit B to make any changes and ask the court if you can change your deadlines. So big mistake. Lots and lots of paralegals don't read every single paragraph of that order and think that they're supposed to use that case, and they file it, and it's wrong. You're not supposed to file that. And plus, it's a lot more work. It's so much easier just to file a notice of final service and saying that we served the defendant and now you can issue the case management report. And the next page, I think we're going to focus now on Volusia County. And like I told you, this is the county that we're lucky that we are practicing in. We love when we get a case in Volusia County. We get cases all over Florida. So we're dealing with every county. But if you are just working here, it's nice because in Volusia County, if you want to go to the next page, this is it. This is what it looks like. And you should have a copy of this. Everybody should have gotten a copy of this because this one, I kind of want to go through this whole thing with you. So if you have a copy of that, let's look at this for a minute. This is what is going to be filed. You're going to serve this with your complaint and you're going to file it in Volusia County. And I think it says here how that's supposed to happen. But the first and foremost, it starts out, this case management order is issued in accordance with the administrative order of the Florida Supreme Court and the 7th Judicial Circuit. So right there, they went back to that very first Supreme Court order that came out, and it's dictated by the 7th Judicial Circuit. Case management designation. Civil cases in which trials by jury are demanded are designated as general cases. So we'll see what Volusia or the 7th Judicial Circuit did. They're going to designate it. If you have a jury, you're going to be general. And if you don't have a jury, you're going to be streamlined. All other cases are designated as streamlined. Cases subsequently designated as complex follow the rule 1.201 of the Florida Rules of Civil Procedure. So you've got to click onto that great link that I showed you. Go to the Florida Bar, pull up your Rules of Civil Procedure, go to 1.201, and you will see the rules for complex cases. And you're going to follow that, and you're not going to follow this. It says right there. Are exempt from the requirement of this order, and you will follow the procedure as outlined in the rule. So complex cases are different. When is your projected trial date going to be? Well, again, that is the reason for the Supreme Court order. For general cases, the projected docket sounding and trial order will be 18 months from case filing. So we filed the case today, October 2nd. We need to put somewhere, either on this paper or however you want to calendar, what is 18 months? I use 547 days. It's 547 point blah, 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 or some people just use 540. Remember, it's a projected date and you're going to use this date to calculate some of your deadlines. But 18 months, that's how I use 18 months. Or 12 months from the date of the order. Well, whichever one is later. So why would we use 12 months from the date of this order, which is usually the date we file it, October 2nd. So 12 months from that date, or 12 months or 18 months from the filing, which is, if we file, it should be just, it should just be a week or so. You do have a lot longer to file a complaint, but in most cases you do it pretty fast. So you're going to take the longest, and it's usually the 18 months from the case filing. Excuse me, I said from the service. It's 18 months from the case filing or from the order. Streamlined cases are the projected docket sounding and trial date must be 12 months from the case filing or 6 months from the date of the order, whichever is later. It doesn't, again, because this order doesn't talk about complex, it's not going to tell you that if you have a complex case, it's going to be 24 months. So it's 12, 18, and 24 is the general rule for the 3 categories. Service of process, it's going to tell you your cutoffs for serving your complaint. The complaint should be served, the initial process, 120 days from the date of the filing. If you go past 120 days, I'm thinking that they're giving you, according to this, it says you can apply motions for extension of time to complete service must be filed no later than 10 days prior to the expiration of the 120 days. So on the 110th day, if you haven't if you have not served your complaint on the defendant, you better get that motion for extension of time in. If not, 120 days will pass, and guess what? It gets dismissed. Because it says right here, the parties, I believe it says it right in here. After expiration of time for service, including any extensions, any unserved defendant will be dropped from the action, or the case will be dismissed without prejudice as appropriate. And you guys know what prejudiced and without prejudice is? No? Okay. Prejudiced means we can't bring it back again. It means the case is over. You can't file on this issue ever again. Without prejudice, it says we're dismissing this, but we have the option to refile our case. So that's what they're saying. If you do not serve the defendant within this time limit, either the 120 days or the extension of time, and I think they give you what, another 90 days after that, if you file that motion for extension of time timely, they're saying that we may dismiss it without prejudice. We're going to dismiss it. You have an opportunity to bring it back, but this case is over. You have not gotten the defendant served. Why does it take so long to serve a defendant sometimes? Because the last known address they don't live at anymore. Oh my gosh. And they've moved out of state, makes it even worse. So you may need all of this 120 days or what, 210, whatever it is, more to find that person. So if you don't find it, they're going to dismiss it, but you can bring it back after you figure out where your defendant lives and you can serve them. All right, then they give you dates for adding new parties. You file a complaint and you realize that you want to name another defendant in your case. So within 90 days of the completion of service, see, you got to read these closest. Some of them say from the filing date, some of them say from the completion of service. So you have to, the deadline for adding new parties to an action is 90 days after the completion of service of the process on the initial defendant, or 60 days from the date of this order. So whichever one is longer, that's the date that you're going to calculate adding new parties. Objections to pleadings. So what have we decided we've been told our pleadings are? We have a complaint, we have an answer, motion to dismiss. What else do we have? Our responses, our objections, anything that is to that initial pleading, the initial pleading being the complaint, the answer or any responses to that, these are your pleadings. So objection to pleadings must be filed no later than 20 days from the date the pleading is served upon the objecting party. So the complaint is served 20 days after that, you better file your answer or it's late and we can have the case taken off. We can get an order dismissing the case and getting what we want. Or now you've answered and we object to your administrative, your affirmative defenses. So we have 20 days to object to your affirmative defenses. So it goes on and on. Motion to dismiss. We have to respond to your motion to dismiss within 20 days. So after every pleading is filed, you have 20 days and you need to mark that. You're not going to know other than your first when their answer is due because you filed a complaint and they have to answer within 20 days. You're going to have a continual obligation to continue to put that deadline in after every pleading is filed, to put 20 more days for a response to it. And on the next page, here we're talking about the completion of discovery. So all of you know about written discovery, but there's a lot more discovery that's going on. All of your depositions are discovery. That's a way of learning. There's a lot of different ways to do discovery. So disclosure of experts. So I kind of went too far there. Disclosure of experts. So 75 days from the docket sounding or from the trial date, because I think at the beginning I skipped something here. When you're figuring out what your docket sounding and your trial date is, they're all calculated on the same date for the case management. Now, when you get a trial order, they're not going to be on the same date. They're going to be on 2 different dates. But for the case management, your docket sounding and your trial are going to be on the same days. And so 75 days before the docket sounding, the plaintiff, they're the people that are seeking affirmative relief. We're asking for something, we're seeking affirmative relief. 75 days, we have to tell the other side who we're going to use as our experts. Then 60 days for the person who is not looking for or seeking affirmative defenses, the defendant is going to tell us who their experts are. And that's the last day. Why do you think it's important that you know what these dates are? That we tell you when our experts are due, or who our experts are. If you don't file it on this date, the other side can file a motion to strike for not timely filing and telling us who your experts are. So it's very, very important that, and this is where I made a mistake, and it's scary. I cried that day. I cried because they did file a motion to strike our experts. It was one of those case management orders that said, look back on the trial order, trial order, case management order. We got a trial order. In the trial order, it said, all other deadlines look to your case management order. I had deleted my case management times in my docket. I didn't have. Well, they filed theirs, which was 15 days after mine should have been filed. And I went, why are they filing their experts now? I don't have a deadline for this. I go back and I look, and the first thing I did is I just went to my attorney and started crying, and they filed a motion to strike our experts. It was a mistake. And if that is brought up before the judge, a lot of times the judges will understand if it's because you are doing it on purpose or they find that you should have known. A lot of times they will strike your experts. I haven't had a case where they've have struck the experts, but you don't want to be the paralegal that caused that to happen. It's really important that you get these, that you serve your experts 75 days or 60 days prior to the trial. Disclosure of fact witnesses for everybody, that's for both parties, is 60 days before the docket sounding. Service of written discovery. Okay, those are your interrogatories, your requests for admissions, your request to produce. Any written discovery that goes to the other side has to be served before 45 days before the trial. All other discovery has to be completed 10 days before the trial. That means all depositions have to be done, all answers to discovery have to be done. 30 days, so they give you extra time. If you file interrogatories on the other side on 45 days, they have to be back when? In 30 days. So you're going to get all the answers back before 10 days. Discovery is done at 10 days before trial. You know everything you need to know. There's no outstanding discovery. So now then they tell you about pretrial motions. All pretrial motions must be filed no later than 30 days prior to the trial date. Pretrial motions filed within 30 days, 29, 28, 27, will not be considered if predicated on matters the movement knew or should have known with the exercise of reasonable diligence at least 30 days prior to the trial. So what are they saying? Don't be lazy and file your I forgot to file my pretrial motion, motion to strike, motion on discovery. Any pretrial motion before trial, I didn't get something that I need before trial, has to be filed more than 30 days before trial. And then it has to be set, and they don't talk about. So because of the busy court calendars, hearing times may not be available to consider motions filed close to the deadline. The inability of a party, to obtain hearing times will generally not constitute grounds for continuance of the trial. Many times the parties get to trial and they're not ready. And they want to continue the trial for 3 months, and they want to ask the judge, well, if you've been lazy and you haven't done what you're supposed to do, and the other side knows, because they're usually asking you for this information and asking and asking. If they got an email train where they've been asking you, or they've been doing the right thing and you haven't been responding, don't ask the judge for more time, because the other side's going to say, we don't want more time. We're ready. You have not been responding to us. You just ignored the case and now you want more time. That's not right. And the judge doesn't like that. Service of this order. So now all the way down here, we find out what we were supposed to do when we filed the complaint. For cases after April 30th, let's skip before, because that would be a really, really old case. For cases after April 30th, plaintiff is required to serve a copy of this order on all parties together with the service of process. So again, Lucia's great. Court, serve it on the other side, calculate your deadlines, move on, life is good. There's nothing else that you need to do. Extensions or continuance, again, the court hereby adopts a firm continuance policy in this matter and will only extend deadlines set forth in this order upon showing of good cause. Good cause, we found out in discovery that we need to do more discovery. They told us about somebody we didn't know about before, and we need to extend our discovery. That's good cause. The judge will typically say, you're right. This, you probably should have known this before now, but now you found out you do need more time. Sanctions, failure to comply with the terms of this order, that's how important it is, may result in sanctions against the offending party. So let's look at the calculation of dates. You're gonna have to click everything. So let's say we filed the complaint today. Click on that. Click October 2nd. So we filed, and we might want to write that down on here. We filed our complaint October 2nd. Click again. So now we've gone on to, and right here on the other side is a beautiful calculator. You can put in there 457 days after October 2nd, and it is going to tell you April 1, 2025. That's our projected trial date. Let's say that within a week, you can click on that, we served the complaint. So now we've got the date it was filed, we've got our projected trial date, and we've got the date that we've served our complaint. We are going to calculate based on those 3 dates through the rest of this order. So the first thing it says, service 120 days from the filing. Well, we've already served it. We served it October 9th. We do not need to calculate the dates of 120 days. Deadlines for adding new parties. Well, what did they say? 60 days from the service of the complaint or 90 days from the date of this order. Which one is latest? So which one is latest? 90 days, right? So 90 days is going to be January 8th, 2024. Objections to pleadings must be filed. Well, again, I told you the only one that we can calculate is the response to our complaint, which is 20 days from the service of the complaint. So we can only add that one October 30th. That's 20 days after October 9th. And that's the date that we should be expecting their answer in. Now we get their answer and we know any response. Now we can calculate another 20 days if we need to, which is going to take us into November, around November 20th, probably. And we know if we have any objections to their answer, we have to file it before that date. Disclosure of experts. Again, that's what I told you. This is an important date. We know by January 2025, why do we need that in our calendar now? Are we going to remember a year and so many that we have to get our experts out? So get that date, get it into whatever docking. We use something called Clio in our office, but you can use Outlook. Every office is different, but get those dates on your calendar. The defendant, and it's important that we know on January 31st, what if they don't file their experts? What are we going to do? To strike their experts. Yeah. So I had one paralegal in our office that thought the only thing that was important was to docket when we had to. And it's very important, but we also need to know when the other side has a deadline, because maybe we can get their experts stricken and that would help our case. I mean, it's just a little theory there, right? Disclosure of fact witnesses. Now, experts are anybody who, because of their training and their expertise, can hold themselves up as an expert. All of our other witnesses, plaintiff is a witness, defendant is a witness, the person who was at the house when something happened is a witness. Those are your fact witnesses. They saw something happen. They have information. So those have to be disclosed 60 days. Boy, that 60 days is a very busy day for the law office to get all of that information served on the other side. We said 45 days prior to docket sounding, we have to serve all of our discovery. You see that come up and you go, oh, I forgot I wanted to ask them. Let's get our discovery out to them so that we met that deadline. Then 10 days before we're done, and that is March 21st, 2025. Pretrial motions must be filed no later than 30 days prior to trial. Well, that's your drop dead time is February 28th. But what do you want to do? Maybe you want to calculate 30 days before that, 60 days before that. Do we have any motions? Has something happened in the case? We want to file a pretrial motion, because that's where you're probably going to draft the first, but the attorneys have got to look at that. They may have ideas. They're going to do more legal research. It's can be a process. Some of those motions can be very lengthy. So they need time. They are running cases and everything else. Drafting a motion could be very time consuming. So get your deadlines well before that, before motions have to be done. There's another thing, and it's not on this. Proposals for settlement have to be filed 40 days before the trial. A proposal for settlement is, we're proposing to you that we'll take X amount of dollars to settle this case in its entirety. So either side must file that 45 days before trial. And those are really what's going to happen in Volusia County. Brevard County, what is that? Brevard's and Seminole. They're right here. They're our neighbor. How many times do you think we might have to practice there? A lot. We practice in Brevard a lot. Their case management orders are completely different than this. You go onto their site and it's beautiful. If you go onto their site, they have a video, and they will, and if it's the first time you're working in Brevard County, I suggest you listen to it. It'll tell you exactly what they want you to do. But Seminole and Brevard, the only difference between the two on their orders is Seminole has an electronic signature, and you have to put a JJJ or a DDD at the bottom of the order. And in Brevard County, you don't. You just do your regular signed on such and such day of this year. But in that one, you download. You have to serve one that is not filled out with your complaint. But within 30 days, the parties are to have met, discussed these dates. These dates are filled out on a case management. It's not like this one where they just give it to you. We actually, between 60 and 90 days, between 120 and 150 days, we decide how many days before trial to plug into each one of these boxes. And then, so they meet, they do that. And then there's an order. You put those dates on the order. You take the order out of this. I mean, it's a process, because you've got this one Word document that the plan needs to be filed in e-filing, but the order doesn't get filed with it. So you have to take it out of this Word document and make it its own order. So you file that, then you take the filed order and the Word document, and you send those to the JA or the trial coordinator. And then they'll sign the order, file the order, and you'll have both the case management plan. Yeah, that's awesome that you're bringing that up. So let's scoot down a little bit. So that's the video I told you. If you ever file in Brevard County, that's a fantastic video to listen to. It's going to tell you exactly what I pretty much just told you, but in much more detail. And then if you go down a little bit further. So civil cases filed after April 30th. You click on that, the very first one. And then you have your Exhibit A for streamlined cases or Exhibit B for general. And then they give you a sample form. Do you want to know? Oh, before you clicked on that, I wanted to show you, tell them something. Do you want to know what the difference between these two are? And you're not going to know this until you work. These two are going to be brevards. And it's going to have the order with the, I told you the order that you just fill out. But if you click on the one that you did, the sample, the yellow sample, see how it says Seminole up there? If you want to go all the way down on there, so you fill out all these dates. This is your case management plan. And then you keep going down and keep going. Here's your order. You've got to extract that and make it a separate document. And then if you keep going down, you go down and then it's a lot. Seminole County, Florida on DDDD. That's an electronic signature. So what happens is when you submit it to Seminole County, they use their electronic to sign the judge, the date the judge got it and his signature. You won't get back one with it filled in that you will in Brevard County. So until you're really working in these counties, you don't know these little, but it's all about reading and reading and reading. So you're one step away from, we're procedural paralegals. Attorneys, they go to school and what do they learn? They learn the law and they learn how the research and how, which case is the, you know, the case that we want to use and everything. We are the procedural gurus because attorneys come out of school and they don't know what we know. And this is what we know. And what we know is by reading and reading and reading, because every single case is different. And they're going to rely on us as long as every time we do a good job and we don't get them in trouble, they'll rely on us. So if I gave a paralegal any advice, it would be double check, read these orders. So that's Brevard County. Did you want to go back in there and we'll look at some of these dates? This, if you do that, you're going to have to download it, click on the sample. Yeah, so let's look at that. So you have, again, the same thing. They want you to put the response for the first day. That says January 15th. I don't know why it says that, but you pick the date that you serve the complaint. Then afterwards, deadline for adding new parties, 60 days from the response date. They're not really giving you a choice. I think in Brevard's, they say 30 to 60 days, and you pick one, and that's how you answer it. Deadlines for witness and exhibit lists, 60 days. Then 150 and 120. So this one's been filled out already.
The sample.
Yeah, and
For Seminole.
For Seminole, but it's very similar to Brevard, but they filled out the dates. Brevard's is going to say 120 to 150 days, and you pick out what you want. Whereas Seminole's is giving you a sample of what it should look like. It should say 120 days prior. You're gonna, yes. So
this is the.
Well, it's both of them.
Mm-hmm.
And then Seminole gave you the example. So what they did is they picked, you pick. Exactly. You would pick right here. You would pick, do you want that to be 60 days before trial or 90 days before trial? We usually pick 150 days for deadline for the expert disclosures for the plaintiff. We usually pick 150. And then then 30 days later, and I think it says in here, it'll be 30 days later, then we'll pick 120 for the defendant. Everybody, both parties are going to be 90 days for the witness and exhibit list. Objections to pleadings, you're going to pick one of those two. Deadline for discovery, we usually pick 30. Deadline for motions, 15 to 30 for dispositive motions. That's usually your Daubert motions. We're not going to talk about that because I don't understand those either. And let's see, deadline for mediation. Well, that's 45 to 60. As the plaintiff, we really want it sooner. So we're going to put 150. The date, same date as our experts. If the other side doesn't want it and says, no, we want it 60 days before trial, fine, we'll change it. But if everybody agrees, the other side agrees, the judge agrees, we're gonna wanna try and make mediation sooner. Because if we can mediate and resolve this case before we start on all of these exhibit, experts and everything else, we would like that. Defendant may not, they may just, want to go right to the end, whatever, it doesn't, and then we can't push it. But that's the only one that I personally deviate from. I try to put it a little bit sooner in that one. So, and then you get both, you meet and confer, you file this on the date, and you put both parties on this second line. I mean, I have a copy of a filled out one on my computer, but you would put your attorney and all of his information here, the defense, or if you're the defendant, and whichever. You can just put both parties there. We fill it out for them. We make it easy for them. We fill everything out and send it to them so that they can meet with our attorney and decide if those are good dates. And then your case management order, which you have removed and put in a new Word document, you fill in those dates that you put. And if the judge agrees with it, you're going to send this to the judge. He's going to sign it and file it in the docket, and that's your order. And you've got an order. So compared to Volusia, which one's easier? The first one that we filed. We calculate the deadlines were done. This one, we have a lot more work to do, and we have to get the attorneys to meet. I think Brevard does this because it's a good opportunity to get your attorneys to meet at the beginning of the case, and maybe they can narrow some of the issues and get this resolved. So I think that has a lot of reason why some of the meet and confers are there. Then what do we have next? Oh, so now we're working, we have discovery. Now we're going to talk, and this is where I'm going to tell you about that rule, that 1.440. This is when a case is at issue. This is what it says. When a case is at issue, an action is at issue after any motion directed to the pleading. So you're never at issue until the pleading part is done. No such motions are served 20 days after service of the last pleading. A party may waive and do so by filing a notice for trial at any time after the last pleading is served. The extension of cross claims among parties shall not prevent the court from setting the action for trial. Notice for trial. But what I kind of want to focus on here is 20 days after service of the last pleading, the party entitled to serve the motion directed to the last pleading may waive, and they may file a notice at issue. Notice for trial, thereafter, any party may file that, and the action could be letting the court know that you're ready to set trial. And if the court does setting the trial, the court will find the action ready and set it for trial, and then you'll get a trial order. But notice that first one, may. My attorney and I, in the 9th Judicial Circuit, they say in their case management order, right after all of the deadlines, and that's Orange County, the 9th Judicial Circuit, they also file their case management order at the beginning. So you don't have to do a lot with that one. But one of their paragraphs say that when the case is at issue in accordance with Florida Rules of Civil Procedure 1.440, you are to file a notice of trial. And my attorney said, I want you to start deadlining 21 days after to file a notice at issue. That's what that rule says to do. And I said, no, it says follow. Well, I was home working that day, and we were going back and forth, and my husband was home working. He says, who are you arguing with? And I said, I wasn't arguing. We were discussing the issue here. She wants us, well, we know, paralegals know, if we file that 21 days after the answer, or if we've objected to their affirmative defenses, they may put the trial in 30 days or 60 days. And if they do that, what's happening to our lives? We've got to rush. We've got depositions to set. We've got discovery to do. We got a lot of work to do. And I said to her, I said, no, I don't think that's what it means. I think we may. A case can be at issue then, But let's wait until our discovery depositions are set. At least we know when they're going to be finished. Let's file the notice at issue. Now, some Miami, probably Dade County, Tampa, some of the bigger counties, I have a funny feeling you could file a notice for trial and it may not be set for a long time. But I know that in Volusia County, Brevard County, and Orange County, if you file a notice at issue and you say you're ready for trial, they believe you. And they're going to put you on a trial docket, the very next trial docket. And so with those, my feelings were that no, you don't file it on the 21st day after the last pleading. If that's the rule, if Orange County says that's when we're supposed to do it, let's call the JA in that case and ask her when we're supposed to file a notice of issue. Do we have to file it on the 21st day or can we file it? And I bet you anything the JA is going to say to us, no, wait until you're ready for trial. But 21 days, if it's another county that doesn't do that, absolutely file it. If you're a plaintiff, you want it filed, you want it on a case, you want to move it along. You have a plaintiff that needs some relief, file it on the 21st day. But if you know the case that they're going to put it on really, really soon, you may want to just look at your calendar for the best time to file that notice at issue. I think that I'm going to show you what a case management order was not. Okay. And that's what I kind of overwent that one. Do you have all of your depositions set? Do you have your written discovery complete? Do you have your inspections complete? These are events that if not scheduled, you could cause you to miss your deadlines if trial is set too soon because you just won't have enough time to get it done. So just know your judicial circuit, how they set trials, and know when to file your notice at issue. This is a trial order from Volusia County, and this is what it will look like. Trial date of the docket, the trial is going to be on the December 4th, 2023 trial docket. On the docket sounding is going to be November 29th. These are all going to go on our calendar. If your appearance is in person. That's the other thing about COVID. It has opened up a new world for attorneys. Hearings and a lot of things are done right on our computers now. They can attend 3 or 4 hearings in a day, whereas before, when especially in ours where we have cases all over Florida, they could just attend 1 hearing, in a day because they have to travel or 2. Now we can do a lot more. We can have a hearing in the morning, a deposition in the afternoon, a mediation in the morning, a deposition in the afternoon, all because they're not even leaving their desks to have this done. So be careful now when you have a trial and you have a docket sounding and it says that you must appear in person, you've got to build in the time on their calendar. You've got to, if it's in Brevard County or Seminole County from Daytona, it might take them a half hour to an hour to get there. So you got to build in that time for them to get there, and then don't schedule anything an hour after the hearing because they got to get back to the office. You might want to think, you might ask them, well, on your way there, can you make a phone call? But that's about it. So be careful. If something is in person, make sure you put it on the calendar that way. You got to drive there. It's not. A pretrial conference, they don't give you a date. There is a couple of judges that will also file a notice after that setting the pretrial conference. But if not, 45 days before trial, you need to schedule a pretrial conference. Then it tells you where to go to look up their procedures for the court. Go there, download those, put them in the file. We're on a trial docket now. We need to know what the procedures say. We need to follow those. And then familiarity. Now, what Volusia County does on the next page, they give us this beautiful, and I think Nathan sent this to you, they give us this beautiful compliance times under their procedures. I love this. It makes life really easy for us to figure it out. Submission of a agreed mediation order 75 days before docket sounding. Now, remember, your mediation doesn't have to be done until docket sounding. So what are they saying for you to do 75 days before? They want to know that you've got a notice of mediation set up, that you have got this scheduled. So 75 days before trial, they want to know when your mediation is and make sure that you filed a notice of mediation. Disclosure of expert, you haven't done it already in your case management order, and this order comes out before you've done it. You have to do it 75 days before trial. Now, if the trial's sooner, now 75 days is sooner. So again, these days take over what you had put in there with your case management order. So now you're on trial. Cutoff for pretrial motions, cutoff for interrogatories, exhibits, discovery cutoff. They're very similar. Those are pretty much same days. It's just they're going to change because now you're going to have a real trial date. Hearing cutoffs 10 days before trial, pretrial meeting 10 days, completion of mediation anytime before docket sounding, pretrial statement delivered to the court, jury instructions. Now you're really getting into, you're really close to trial now. And that's a lot of work. You have to see where they have an attorney meeting, pretrial meeting, right there before that pretrial meeting. I want the case settled. I really am very upset that we haven't settled the case by the meeting of the attorneys, because I've got to take all those exhibits, put them in folders, and share them with the other side. These are our exhibits. It's a lot of work. You've got to get the pretrial statement ready to discuss with the other side. So you've already drafted the pretrial statement. You've got to get the jury instructions downloaded. You go to the Supreme Court to get your jury instructions, but you've got to, there's a trillion of them. Which ones apply to your case? Which ones what jury instructions are you going to use? You get those and you fill them out for your side so that you can discuss them with the other side. So it's a lot of work, and I've got about 3 of them coming up, and guess what? I'm going on vacation. So now I had to go before all of this and get everything done before I leave so that it's ready. It's not the final product. What we do is not the final product, but we act like it's going to be. We act like it's our case. We try to think of everything we can think to make our attorney's life easier. They're going to read over it. They're going to say, no, I want another jury. And, I'm going to go grab another one. They've been to trial many times. They know what they want. They make the final decision. Please don't ever file anything without them looking at it first. We are not attorneys. We're paralegals. We may know how to do things sometimes better than they do, because we've been reading all these rules. We've done it a million times. Doesn't mean we can file it without them looking at it. They must look at it. It's their signature on that document. We are not attorneys. So biggest thing I can tell you is to be an attorney without being an attorney. Think of things in every case, get these orders, read through them, look at your case. What are we missing in our case? What do we still need to get done before 30 days or 45 days? So this is going to happen when you've been a paralegal in civil litigation for a while. When you're a new paralegal, please get yourself a mentor to walk through all of this. Ask the questions. You get an order. Sit with someone. Go through it the first time you put it in there, because they may tell you the attorney you're working for likes you to add different deadlines in there. And then and I'll tell you when I finally felt like I knew what I was doing, and it took a while, was when we went all the way to trial. And when I got into that trial with those attorneys and I started seeing how that discovery we did so many months before made a big difference. And why, if I forgot to put a document into the file and it didn't get as an exhibit, it could be the document we needed for that trial and it didn't get disclosed to the other side. There are so many things. Once you see that, you go back to these and you understand why they do what and say what they do. And it makes you able to do that too. I think the last one is just one that I filled out and how I work on it. So this is one that I did. The trial's on December 4th. I put the docket sounding. I put all of my dates in there, and notice how 60 days before docket sounding, but there's a couple that say trial date. So you've got to be real careful when you're reading these that you're doing all these docket sounding, and all of a sudden you don't want to put 30 days before docket sounding for the trial. Then they like to even throw you off a little bit more. What if you've got your pretrial conference set already? So 10 days before docket sounding or 10 days before trial conference. Well, docket sounding is usually right before trial. Sometimes a pretrial conference could be a month before that. So that's gonna change some of these dates a lot if you've got a pretrial conference scheduled. Then I also, so I put those 45 days before trial and schedule. If we want a pretrial conference, we've got to schedule that 45 days before trial. So I put those deadlines in to put in mind too. And then absolutely with all of these, if they're important deadlines, I will put it's due in a week, it's due in 2 weeks, and give myself reminders prior to that deadline so I don't forget. Or I've got a busy schedule. When can I fit that into my schedule so that I meet that deadline? It's not always that I want to do it 2 weeks before, but this, I've got discovery due, I've got a couple motions, I've got, some different things to schedule. When can I fit that in that I can get that done for the deadline? So that is about it. And any questions online or in the classroom? Yes, absolutely. Between the docket sounding, I believe, because I don't go to those, the attorneys do. I believe that's telling the court why haven't we settled yet, and what our issues are, and where the judge's timeline is for trial, where we're going to fit, and when he's going to put us for our trial. Okay, the case management order gives us deadlines. A case management conference is when they meet and they discuss these things. Some of them require you meet and have a case management. The federal court requires that before you submit the report, you have a case management conference per the rule and discuss all of these things. Some of the 7th Judicial Circuit does not. It just gives you the case management order. It tells you if you want a case management conference, there is a rule. If you look in the rules, you can look for case management. You can set up a case management conference. Only if they say it's mandatory. If it's not mandatory, you still can have it. You can still have a case management conference. There are some things that we need to discuss before the judge. Can we set up a case management conference? And the judge will set that up. But then, so right here, it's saying if we want a pretrial conference and they haven't scheduled one, we have to do it 45 days. So if the judge never sets a pretrial conference and then we don't set one, it won't happen. And it doesn't have to happen. You have to go to the docket sounding.
The case management order is in this order, it has to be done. The order itself, the case management order has to be done
per that judicial circuit. And like I said, that is the biggest hurdle that we have is finding out what each judicial circuit tells us what to do. So that probably is, and I think that that's what they're trying to do. I think that eventually they're going to come down and say, there was a work group that was said at the time that they did this order, and I don't know what happened to the work group. I don't know what came out. All I know is what we're dealing with right now. We're dealing with 20 circuits with 20 different case management plans or orders.
I have a question.
Absolutely.
So the dates you're pulling on this one, they came from a pretrial order because the case management order is more about the projected. Like the docket sounding and the trial is estimated at 18 months.
Correct. But
But this one has the specific dates that you're allowed that you can calculate.
In that case management trial order that we had, it told us when the date of the case, when we're going to trial. If you want to go back 2 slides. Right there. So we get a case management order. It's telling us
this is the order.
This is the actual order.
So this is coming
after
the initial case management order.
And that's why, what if on this
is like the pretrial order.
This is the pretrial order.
So it comes later after
Absolutely.
Right, so the first dates are more like projected dates.
Correct. Correct. That's where
established.
case management.
And then
are
once you're
projected.
further down the line, the courts will,
And that's after you file the notice telling them, that's why I told you.
right,
That notice for trial, it gets filed, you're gonna get one of
you
these.
get one of these.
Right.
So they're not gonna go off the 18 months and say, okay, well, we'll put you, they're gonna.
Well, I'm gonna be honest with you, some of them
Maybe.
do.
Okay.
You know, they say, hey, you're a CMO
18
since you're
months,
not
there you
ready.
go, yeah.
There you go. Another one's gonna say, oh, you're ready for trial? Okay, let's have it for trial. We're gonna do it in X amount of days. I think in the order it said it can't be anymore, and I believe it was, if you want to go back a couple of slides, I'll tell you where to stop. Right, oh, go on back. So right here, if the court finds the action is ready to be set for trial, it shall enter an order fixing the date for trial. The trial shall be not less than 30 days from the service of the notice for trial. Not less than 30 days, but it could be 31 days. You know?
Right.
So you really know your circuit. If you've worked in a circuit, if you haven't worked in a circuit and you're not sure, call the JA. If they have a trial coordinator, call the trial coordinator. If I file a notice at issue, how far out is your court going to set this trial? Are they going to set it on the very next trial docket? Or is the docket so backed up, honey, you're going to be good if you get one in 2 years, because we just have so many cases. And you know what happened? They did an emergency order kind of extending some of these dates after the personal injury. That just came out this year. There was a new law or a new statute that came out that shortened their deadlines to file things, statutes of limitations. So they used to have, I forget how many years to file a personal injury, and they moved it down to like 2 years or something. So all of these people have all of these cases they haven't filed on yet. They've been working with the other side. They've been working them, but they haven't filed the complaint yet. And they were, oh my gosh, hundreds and hundreds. The clerk court was going crazy. They were getting so many filings. That was in the spring of this year. It was crazy. And I think it.
And also the contributory negligence change.
Did it?
Yeah, because it went from, 51%, or it went from 0 to 0. Like, in other words,
Yes.
you could still get a recovery.
Uh-huh.
Even if you were found to be like, 90% at fault, but now it has to be, you have to be less than 50%. Yeah.
Right.
Yeah.
Right. And I don't work in that law, so I don't know that, but that's
That was a
true.
good
I
one
mean,
where they had to-
when they changed laws like that, boy, just like what happened with the motion for summary judgment. Oh, and then time. I think one of these, I told you, we were talking about how to calculate times, and it goes off of the, we want to go back. Let's show you. Go one more. Oh, yeah, that's right. It's got all of that in there. So that, but general practice, the Florida Rules of General Practice and Judicial Administration.
Oh,
That one, when we went on to Florida Bar and I pulled that up, they have a rule and it's 2.514. It tells you how to calculate times. So in this rule, if you go to yes. Yeah, you just, oops, you're back at there. If you go there, there's one thing I want to show you that it kind of messed me up when I got a federal case right after that. Yeah. 2.5. 2.5, I think is
5, yeah.
5.1. Use of electronics.
Computing and extending
Yeah,
time.
thank you. So in here, if you go down, let's see, begin counting from the next day, that is not a Saturday,
Yes.
Sunday, or holiday. What if somebody files something on Friday? When do we start counting? What if it's a holiday? Tuesday. Yeah. Okay. That's our Florida rules. Guess what the federal rule says?
The next day.
The next day. Well, I had discovery due. This only happened a couple of weeks ago. I had a federal case. I've got maybe 2 or 3 federal cases out of 50. Okay, so yes, I used to in employment law, I was just almost solely in federal court. Now I don't work in federal court as much, but I do like it. So I got discovery. I went in, guess what? They filed it on a Friday. I calculated it. So the day, let's say it's a Tuesday, I get an email from the other side. When can we expect your discovery? It was due yesterday. I said, well, I have it. I'm working on it. It's due tomorrow. So, but I didn't say that to her. I went and looked because I said, I'm not gonna be fresh with anybody and say, oh no, you're wrong. It's due tomorrow. I checked myself because I can make a mistake. I made a mistake. I used the Florida rules and I didn't use the federal rules. It was due yesterday. So instead of saying, oh no, it's due tomorrow, I said, oh my gosh, I am so sorry. I calculated it based on the Florida rules and not the federal rules. Is it okay if I have it to you tomorrow at the latest? And she can, absolutely. But do you see how these rules, how you have to know what your rules are? She could have been mean about it. She wasn't. I wasn't, and I definitely wasn't mean about it. I made a mistake, and you know what I did is I copied my attorney so he knew what happened. That is if I tell you anything, if you make a mistake, the first person that has to know about it is your attorney, because mistakes can be fixed. You explain what happened. We're human. We make mistakes.
Only if you know about it.
Yeah. If they find out about them 3 months later when they're standing in front of a judge and the other side points out their mistake and they never knew it happened, oh my goodness, that would look very poorly on you. Please make sure you let everybody know that you made a mistake when you make a mistake, and beg forgiveness. Yeah, and say I'm sorry. Yeah, make sure you're sorry. Yeah. So, any more questions? Anybody online have any questions?
I don't see any.
Okay,
Very
do I need to go through?
Oh, wait, there's a question. It is, you should have
What is she looking for?
the presentation.
Okay.
If you look under the weekly module, you'll see like CLE. Click on that and it'll bring up her PowerPoint. Yes.
Yeah. So absolutely, I did. There's also another thing that I asked him to put in your folder. I have this for my use at work because I told you we work in all of the judicial circuits. I have absolutely picked out, gone to each one of the circuits and have a link for where the case management order is to save me time. Oh, that's it. That's it. So I put this in your packet. Absolutely. If you're going to be working in a lot of counties, please use this. Because what I found out, when you go there, if the page is expired, that means that they've redone it. So that's usually a good thing. But again, it's taking you right to the source. And if they've updated it and kept it in the same place, it'll be there. So if you use these and I put a little synopsis under each one of them saying what we have to do as the plaintiff. So for instance, file and serve this order with, that's in Orange County. You don't have to do anything else. Paragraph 5, perfect. Paragraph 5 says that when you file an NOI, you need to ask the other side if they agree to 3 to 5 days and file a notice for trial instead. And this is where we discussed, because do we do this on the 21st day or do we do this when we're ready for trial? But that's what paragraph 5 of the Orange County order does say. But if you have these online, all you have to do is click on those sites and it'll take you right to each one of these sites. So that's my gift to all of you.
Well, thank you very much.
Thank you. Do I need more time or are we good?
We're good.
We're good. Thank you all. Thanks.